Welcome to the final video in the Appropriate Dispute Resolution video series. In these videos, you will be introduced to a dispute between two parties, and we will be able to track the dispute through the alternative dispute resolution processes. Jules and Lauren have now conducted an arbitration led by their arbitrator, Drew. In this video, Drew, Jules and Lauren and legal representatives share their thoughts and views on the arbitration and the results.
Overall, I think that the choice of forum was good for my client. The confidential nature of arbitration means that she could resolve this with little chance of much publicity. It also took place much faster than a magistrate's court hearing, which could have taken months to occur. I'm glad that we could avoid the need to call witnesses on oath or otherwise go through formal evidence like we would in court. This is a much faster way of doing things, even if it isn't always a good fit. As a lawyer, I like a setting that lets me put my client's claim simply and appropriately. This is a small dispute, but even if there was a lot more money involved, we could easily have resolved this in days, not months or years. I do have issues with the expert report and the fact that it was just taken on its face. If this were court, I could easily cross-examine the expert, but the arbitrator decided that he wouldn't issue a subpoena or allow for one in this case. If we lose, this might be a basis of an appeal.
Yeah, I found this completely different to mediation. I basically just sat there unless I was being asked a question. The lawyers were pretty much just talking to each other about legal stuff. I can't say I really understood all of it. I'm glad though that it was confidential because my lawyer explained that Jules couldn't use my confession about the truck driving over the paving against me. So I'm really glad about that. I probably shouldn't have admitted it to begin with. But I do wish that we had resolved some of the issues beforehand. But we can't compromise now, it's in the arbitrator's hands.
I didn't enjoy that. I knew that Lauren wasn't going to tell the whole truth, and we had to spend money on some expert report. I mean, come on. I know that I did a good job. Lauren does too, and I have to go and prove it to an arbitrator. But at least we got to pick one who knows construction law. I guess that I might have enjoyed this more if I understood all the legalese, but my lawyer explained some of it to me. And I guess it was still very different from the mediation. Better than going to court. I just want all this behind me now, because I don't need some judgment against me.
The value of arbitration for my client was clear here. Firstly, this was commercial, fast, and didn't keep him off the road for any length of time. We have resolved the matter in weeks, not months. Secondly, because of the evidentiary flexibility, we could get through 2 witnesses in one day. That might not have happened at court. Also, the parties have split the costs. We were able to agree on an expert arbitrator. This was much better than getting a judge who might have had to have the details of paving explained to him at length. Obviously, we couldn't rely on anything set in the mediation other than the mediation agreement itself. This meant we had to bring evidence about the care of paving. Most of the issues involved are legal, and I think our written submissions will be very important as this is what the arbitrator will take away with him.